Speaker.
The Honourable Phil Goff.
Mr Speaker, the purpose of this bill is to ensure that those who are out in our community, either on parole or on bail, and are subject to conditions imposed either by the court, in the case of Bailees, or by the parole board in relation to those on parole, are subject to conditions of non-use of alcohol and drugs, actually comply with those conditions. Most New Zealanders, Mr Speaker, would be surprised to know that legislation of this nature is actually required for that to happen. All of us would assume that if there's a court-imposed condition or a parole board imposed condition, that you don't use drugs and alcohol when you're in the community at the discretion of that authority, then there would be proper checks on compliance with those conditions. And what we read in this bill and in the regulatory impact statement is that the authorities are telling us very belatedly that there is no legislative mandate to ensure compliance with court or parole board imposed conditions. I find that quite amazing, sir. So you imagine that when a condition is imposed, that there is a way of monitoring compliance, and in cases where there is highest risk, that there is some testing to ensure that compliance is taking place. And the fact that we now learn that that's not the case, I think indicates that the authorities have been rather lax in reporting back to this House that something that all of us would assume was necessary wasn't actually in place. And I have to ask the question, sir, that if the court or the parole board has the power to require testing of compliance with the conditions, and the court can apparently order that, why the court has not been doing it. But we read from this bill that the court hasn't been. Now, this is a concern, sir, because there are some 20,000 people out in our community at any one time that are subject to conditions of non-drug or non-alcohol use. 5,000 on community sentences and 15,000 on bail. And yet the police say that they very rarely test people on bail to see whether they are actually complying with non-use of drugs or alcohol. By comparison, in countries that we would normally relate to in terms of our justice system, the United States, Australia and the United Kingdom, testing is commonplace. So somewhat belatedly, this bill comes to the House. And I am curious, Mr Speaker, that 3 years ago measures were moved to require beneficiaries to be tested for drug or alcohol use. And yet there was no comparable provision for people who had actually proven by the crimes that they had been committed and sentenced for, or by being on bail for allegedly committing a crime, that there was no such provision for these people. Somehow beneficiaries came under the big stick before those that were either convicted criminals or alleged to be criminals. And I'm surprised, therefore, that we got this the wrong way about, that this legislation hadn't come in earlier. But it is here, and it's good that it's here. I believe that it makes sense, and Labor will be supporting it, but we'll be asking questions in the Select Committee to ensure that this is the best, the most cost-effective way of ensuring the safety of the community. There's two fundamental reasons, sir, why we need this legislation, and the first one is public safety. If a person is subject to conditions that they're not meeting, and they have a track record of offending while being influenced by drugs or alcohol, they constitute a threat to the community, and we need to deal with that situation immediately, sir. So there is a need to have legislation of this sort. What the bill also does is that it sets out the methods and procedures for monitoring and testing. Well, actually, it doesn't spell out those in details, but rather it sets the principles that will govern the rules and procedures that will be set by the Chief Executive Officer of Corrections or the Commissioner of Police. Now, this House is rightly careful about delegating authority to subordinate legislation, to regulations about what is done and how it's done. But in this case, I'm glad at least the principles are set down by which the Police Commissioner or the Head of Corrections will set the rules. And they are common sense things, that the drug testing and monitoring be no more intrusive than necessary, that they be no more often than necessary, and they give as much privacy to the person being tested as is reasonable given all of the circumstances of the case. The bill also sets out the consequences of non-compliance, because it's not just a case of testing and finding people that are breaking the rule. It's about making sure that those who are subject to the conditions believe that if they actually don't meet the conditions, there's a good chance they're going to be caught. And that's the critical thing about this bill. And we've seen that in the United States. The United States, that has similar provisions to this, found that they could reduce drunk driving by repeat offenders from around 36% down to nil if those most at risk of drunk driving felt that there was a high likelihood that their abuse of the conditions would be detected. I think those statistics are pretty persuasive. Secondly, in Australia, the experience has been pretty much that you don't do it to everybody. We're talking about 20,000 people subject to conditions. If we were to regularly monitor and test 20,000 people, the cost would be astronomical. We'd be talking about tens of millions of dollars and a huge use of resources. So practicality suggests that what you do is that you test those at most risk of reoffending and those who, if they reoffend, are at most risk of committing a serious offence such as a violent offence. And from reading the regulatory impact statement, that appears to be the way in which corrections and police will go about implementing a testing regime. And I think, sir, that is very appropriate. So why do we need to do all of this? Well, what we know about drugs and alcohol is that they are both major drivers of crime. I think during the time when I was working in the justice system, nearly half of all of those at the time they were arrested reported that they'd been using drugs or alcohol. 48%. Now, if that's relying on them to report it, you can assume that it's not over-reported, it's more likely to be underreported. So nearly half of all of those at the time they are arrested, their behaviour is influenced by the misuse of drugs or alcohol or addiction to drugs or alcohol. And it's even greater when you come to looking at those that are on home detention, on extended supervision or supervision orders. 68% of those that come into those categories are found to have behavioural problems caused by drug and alcohol abuse and addiction. 68%. So what we can do in this area is really important. We'll end up testing somewhat less than 500 out of the 20,000 of people who have conditions imposed on them. But if we target to the people that are most at risk, then we're going to have the biggest impact for the in the most cost-effective way. The costs are reported as being about $2 to $3 million a year. That's a substantial amount of money, a substantial amount of work on the part of corrections and police. But if this is effective, and I believe that it should be effective, then, sir, I believe that that is a good investment of the taxpayer dollar. What we're trying to do here, to sum up, is to ensure compliance. There is no good purpose in imposing conditions about non-use of alcohol and drugs unless you have a means of checking to see that those conditions are being followed, and if there is a breach of those conditions, then there will be some sanctions. And the sanctions will involve either fines or imprisonment, and they'll probably increase the need for prison capacity by a modest amount, by about 10 beds a year. So, sir, I believe that this legislation does have the potential to improve public safety, and the Labor Party will be supporting it on that basis.